My name is Finbar Birmingham at the International Business Times. I'm here with Nigel Kushner, who's the CEO of the law firm W Legal, a specialist in international trade sanctions. We're here to talk about the impact which trade sanctions on Iran are having on UK businesses. So Nigel, first of all, the talks which have been going on between Iran and the West seem to have reached something of a stalemate. What are the chances of reaching an agreement by the July 20th deadline?
I don't think we will reach a final agreement by the July deadline, but I'm cautiously optimistic that in the next 6 to 12 months there's a good prospect of reaching a real resolution.
People perhaps view these sanctions as only ever impacting on Iran or people in Iran, businesses in Iran, but that's not the case, is it?
Absolutely not. Yes, there's been a devastating impact on Iran, but there's also been a devastating impact on segments of UK business.
I would imagine for a small exporter who perhaps has some business with Iran, it must be quite difficult to keep it abreast of the changes in the sanctions and what they can legally or what they can't do.
It's very difficult to keep abreast because they change often on a month-by-month basis. What's interesting is, I act for a lot of large companies with robust compliance systems, and when I go in and do an audit, I almost always find unwitting breaches. They just didn't understand where the lines are drawn. Often the regulations are black and white in certain respects, but they're very grey in others, and they will come to a lawyer to interpret it, and the lawyer isn't in much of a better position because it's totally grey, there's no answer, and in those circumstances we will go out to BIS or to HM Treasury and seek clarification. But I have to say I have many clients who have either simply closed or in one case, which is an extreme case, has gone bankrupt as a direct result of the sanctions in relation to Iran.
That's an extreme example, I guess. What other sorts of penalty could a firm expect to receive if it was found to be in breach of a sanction?
Well, ultimately, directors could go to jail. Any EU national could go to jail, or they could receive a fine of a significant amount for breaching the sanctions.
I've heard a lot about this unofficial banking boycott of Iran. Perhaps you could explain a little bit about what that is and what impact it has on businesses in the UK.
Under the current EU legislation, which includes the UK, it is entirely permissible for any bank in the UK to have certain permitted dealings with Iran, so long as the products aren't prohibited, and there's many products which aren't prohibited, including humanitarian products, agriculture, general trading products, and so long as there's no sanctioned bank involved, it's entirely permissible. But you will not find one bank in the United Kingdom who will willingly or knowingly, to my knowledge, allow a client to transact with Iran, even though it's entirely legitimate.
Why is that?
I believe that the reason for that is a fear of the US and the exposure to being prosecuted by the US.
We have seen banks, of course, over the past year or two, UK banks facing, settlement charges from OFAC.
They have paid hundreds of millions of dollars in settlements. These banks were a little bit naughty, allegedly. They're colloquially known as the strip club banks because what they did, they stripped out, allegedly, references to US dollar payments involving Iran and allowed those payments to be processed, and even if for a split second they went through a clearing bank in New York, they are alleged to have breached the US sanctions by pulling the wool over the eyes of whoever was in the United States, and that's the basis for the penalties that have been given.
But am I right in saying that quite often you'll have a UK business which perhaps is trading directly with Iran? There isn't any US involvement, but the banks are unwilling to be involved in this trade just simply for fear of overstepping the mark?
That's absolutely the case, and I have a number of clients who trade entirely legitimately with Iran who have either had their bank accounts closed or they've received requests to move to a different bank. One example is a travel company who is organising a tour, and the tour goes through Iran on a much larger tour. they received a call from their bank saying, please close your account because one of your tours passes through Iran. I've had individuals who have the most tenuous of links with Iran who have simply been informed, please close your account in 30 days.
These banks aren't really breaking any sort of law, this is all completely legal? Or?
They're breaking no law whatsoever.
And would it be the case that they may be in breach of any sort of Equality Act if it was found that they were doing this on the basis of the person being of Iranian descent?
There is a case to argue that there is a breach of certain acts preventing discrimination, but the challenge is to prove that the bank has specifically acted in a discriminatory way. When you or I or any business opens a bank account, we give carte blanche in the terms and conditions to allow the bank essentially to terminate that banking relationship at will.
Okay. Nigel Kushner, thank you very much.
Thank you.